Listed lordship. On bail matter lordship.
What can be done, sir? Next circuit.
Yesterday lordship. Honorable court lordship.
Why not listed? We don't know. Ki holo, Pritam? Huh? Oh, the file came very late. Unless the file comes, it won't be listed. Yes, next.
We are for admission of criminal admission stage.
You want us to hear? This bench? Tomorrow? Tomorrow?
The petition is being
Are you serious? Next.
My lord, may I permit to mention, my lord, this matter was in yesterday list, but not in today's list, my lord.
কেন গো দেখো কি বলছি Oh, I see. Yes, because there are lesser number of matters today.
My lord,
Today
kindly-
being the last day, sorry. Yes. First,
After getting
after?
getting
Yes.
I want the matter report.
No, it is not in the list. What can be done? Do it before. Do it before the next circuit, sir. All my best wishes. All my best wishes. Call the list. Call the list. Sorry.
My lord, may I be permitted to pray for your lordship's leave to file an appeal without the certified copy? My lord,
We
the
don't-
order.
We do not entertain any mentioning or any submission from inside a motor car.
My lord, I am extremely. My lord, may I apologize? My lord.
Yes. Call the list.
My lord, I am for the petition.
গাড়ির ভেতর বসে
Something put the banana.
Oh, it should be the name is it should be Kamal Shunil Rai.
Sunil Rai.
Let the order dated November 8, 2024 be corrected by substituting the name of the petitioner as Shunil Rai in the place and stead of Kamal Sarkar, as has been incorrectly printed. Let this correction be incorporated.
Deeply obliged, man.
My lord, may I have the indulgence, my lord? My lord, may I have the indulgence?
This has been called on, sorry. Yes.
Pursuant for the petitioner lodge.
So, are they going to call for the injury?
Lordship. Lordship.
Yes.
File a report that there is no injury report available in the.
Item number 3.
But in the very ticket lordship, there is a head injury.
There is no injury report. Orthopod is not available in the report.
But the victim admitted in 2 days in hospital, treatment sheet mentioned head injury lordship. So that side of the head.
On any condition, lordship kindly consider.
Lordship pending lordship.
Head injury is there, but nature of injury is not mentioned.
That's why this is the difficulties, my lord. Without injury report, it cannot be asserted.
Anyway, whatever it is, some injury was.
Yes, Mr. Doctor, the problem is that this is not the petitioner's headache. Any benefit of doubt we'll have to give him. We don't like to do that, but we are. Nature ki charge gulo ki.
P26 307.
Attempt to murder lordship. Attempt to murder.
Release from so.
He is the sole accused.
Sole accused lordship. Charge sheet pending.
Maybe there is the previous in nature.
No. How long? When was the incident took place?
10 August.
Anyway, this is the observation. There is no injury report. Yes, learned advocate for the petitioner and learned advocate for the opposite party, state of West Bengal are present. Heard learned advocate for the petitioner and learned advocate for the opposite party. Peruse the materials in the case diary. This matter was adjourned on the last occasion to enable the learned advocate for the opposite party to obtain the specific injury report. But
We have to direct.
yes, and the chief medical officer of Kuchbihar was also directed that the injury report in the present case is placed before us. However, by order or by letter dated 13 November 2024, the medical superintendent cum vice principal, NJN Medical College and Hospital, Kuchbihar, informed that injury report of the injured person Partho Pal is not available at the record section of the hospital. Stop. Upon hearing the learned advocates and considering the facts of the case and considering the fact that the victim was admitted to hospital, but as there is no specific observation with regard to nature of injury, this court is of the view that in the interest of justice, the petitioner should be granted anticipatory bail. Thus, we allow the prayer for anticipatory bail made by the petitioners.
Let the letter be taken on the file.
Item number 4.
My lord, item number 4, my lord, I'm appearing virtually, my lord. I'm being led by Mr. Rajiv, my lord. My lord, item number 4 and item number 9, my lord, it's the same matter, different petitioners. My lord, can it be taken up together? 4, can it be taken up with 9?
One is
The
proclamation
lordship's-
is.
Okay, petitioner number 4, okay.
Yes,
They are the
four.
two lady accused, female accused
She-
person.
But
my
it's
lord.
indirectly involved.
Okay, just a minute. Okay, you see, you produce the statement of this person, this Biju Sarkar and Sabnam Sheikh, who are present in the spot. 161 statement. The witness, that is Biju Sarkar and Sabnam, let us see.
Actually, they are in the 164 statement.
Okay, let us see.
First of all, your lordships, the proclamation
But can
order.
it
No,
be
no, so
taken
for
up
these two
with-
persons.
Oh, yes, no, this is the.
My lord, can this matter, can there be a short passover, my lord? Kindly, my lord.
And these persons have the criminal
Passover.
incidents. Lots of
Item
cases
number 9
pending.
is the same
No,
matter.
no, proclamation
same
issued
affair.
against,
Can it be taken up
against
along
this
with
three.
that item number 9?
Why? What is wrong with this?
Mr. Rajdeep
My lord, my
was-
senior, my lord, he's on his legs, my lord. Can you kindly consider, my
And
lord?
fixed and next 30 your lordships. LCR also is called to be required as because
Here is not.
they are challenging that the proclamation order is not
got the
correct.
entire certified
So
copy.
it should be considered.
You have got the entire
Lordship.
certified copy.
Next circuit.
Obliged to your lordship, obliged.
My lord, can it be taken up with item number 9? It's the same matter, my lord.
Next, call the matter.
My lord, I am praying for a short pause because there is a jam in the national highway.
Next.
Road block. My lord, can it be pass over, my lord?
This is my renewal of my bail application, my lord. It was registered on my lord, page 8, my 20th May 2024, my rejection, my lord. My lord, petitioner is custody about my lord 410 days, my lord. My lord, petitioner enter into India with valid passport, my lord. After expiry, he stay in India, my lord. Charge under my lord 15 capital F but C.
Some latches and regulations are there. Yes, the trial has started.
Trial not started, my lord. My lord,
After how many days you were apprehended from the date of expiry of your passport? That is visa.
yes, my lord, yes, my lord. My lord, visa was up to December.
Visa was expired on 16th of May 2026.
And he was apprehended
It was apprehended on my lord,
No,
29th September.
after 3 months from the date of any application was made for extension of visa.
This time I have specific instance.
Anyway, let us see the case diary.
Malad, before 14A capital and not applicable, Malad, because Malad, 14 small, Malad, section 14A.
Yes.
is Not applicable, Malad.
I've underlined the facts of the case, Malad. It is.
Can I see the Malad?
Exact application.
Visa expired, photocopy expired for it also. They have not applied to relate it also to an identity that I have done. It's totally possible, you know, that. Very wrong. Yes, anything recovered, that false Aadhaar card?
Yes, yes. Malad,
Where is the serial?
Malad, charge under 14 capital, not applicable, Malad. The maximum punishment 8 years, Malad, 14 capital, any, without any entry, Malad.
No, question is, it is admitted position that his visa expired, but
Yes, Malad.
whether he has made this false Aadhaar card or not, and you have found that to be false, that is the question.
Section 14 applicable, minimum maximum punishment will be 5 years. Not 14, Malad. Paragraph.
No, but the problem is the moment if we release you,
No, I am not, Malad.
Your
Court
exist-
request- Malad, court insures such type of condition or interim bail so that I can comply. Malad, court
no, no,
request-
your presence will be illegal. You don't have a visa.
Malad, I will apply in the meantime, Malad. Penalty
Penalty-
position, Malad, applicant, Malad, section. Penalty application.
Malad, actually, what is there? Today is fixed for 14/11. Today is fixed for production of the accused, Malad, in the lower court, Malad. So that is why the original case.
No, question, that is the thing, you see,
For the civil-
if it is only extension, that is one thing, but if in the meantime he has made some this forged document, that is another thing.
Malad, kindly see the judgment from paragraph 12,
It is there,
Malad.
Malad. See the list.
Malad, from paragraph 12, Malad.
Three. Malad, point number 3 in the civil list.
How many charge sheet named witnesses here?
Total 16.
Total 16, Malad.
Total 16, Malad.
465, please, you can. No chance of an early conclusion.
Malad, kindly fix a time frame, Malad.
We can't. That is the problem. Now the Supreme Court has said.
You see, 400 days in custody,
410 days, Malad. Charge-
410 days in custody.
1 year, 1 month. Charge not framed.
Bangladeshi national bank.
No, you see, had he been infiltrated simply, that would be in a separate case. It's no ground to grant bail. But
His initial
While-
entry was not illegal.
Yes, Malad.
Article 21,
Was holding Indian Aadhaar card.
Article 21 is available to non-Indians also. Speedy trial. ওইখান থেকে বেরোবে না। Which correctional home is he in?
Shiliguri.
Siliguri. And the case is in?
yes, where did you give your address?
Shiliguri.
Oh, this is temporarily decides. Thank you. দার্জিলিং এ থাকে তাহলে দার্জিলিং ডিস্ট্রিক্ট থেকে বেরোবে
যেখানে তো মামলাটা আছে সেখান থেকে বেরোবে সেই ডিস্ট্রিক্টটা।
Okay, the case is where is the case pending?
ফাঁসি দেওয়া।
Shiliguri court.
শিলিগুড়ি কোর্ট।
In Siliguri court.
শিলিগুড়ি থেকে বেরোবে শিলিগুড়ি কোর্টে জুডিশিয়াল থেকে বেরোবে। দিদি এসো।
এটা বলতো judicial entry was lawful, something like this.
The petitioner says that he is in custody for 410 days. Stop. Charge has not been framed. Stop. There are 16 charge sheet named witnesses. Stop. There is no possibility of an early conclusion of the trial. Stop. Am I correct in saying that Article 21 is available
Yes,
to
ma'am.
everybody?
Yes, ma'am. Article 20 are available.
He renews his prayer for bail, which was earlier rejected on May 20, 2024, on the ground of delay in progress of trial. Paragraph. Opposing the prayer, Learned State Counsel says that the visa of the petitioner, who is a Bangladeshi national, expired
23/5/2024. 23/5/2024.
23/5, no, no,
So, minor 16/5/2023.
Oh, 16/5.
May 16, 2023. Stop. Thereafter, the petitioner did not obtain extension of visa. Stop. Instead, the petitioner procured forged documents
Of Indian Aadhaar card.
for forged other card.
Aadhaar card.
Procured forged Aadhaar card and masqueraded as an Indian national. Masqueraded as an Indian national. Stop. November 14, 2024 has been fixed as the date
It's for production of the accused.
for production of the petitioner before the Learned Trial Court. Stop. Paragraph. The prosecution may have a very strong case and very good grounds for securing the conviction of the petitioner. Stop. However, the petitioner cannot be kept in incarceration for an indefinite period of time without concluding the trial within a reasonable period of time. Stop. We see very little possibility of the trial concluding on an early date. Stop. The petitioner is in judicial custody for more than 1 year, 1 month. Stop. The fundamental right, the right to speedy trial under Article 21 is available not only to an Indian national, but also to others. Stop. Hence, without making any comment on the merits of the case, stop. And considering also that the petitioner's initial entry into the country was not illegal, we solely on the ground of delay in progress of trial, we are inclined to allow the petitioner's prayer for bail, but on stringent grounds, and he will not leave the jurisdiction of the Learned Trial Court. And report to officer in charge of Jalpaiguri PS once every week.
Document 7 and 8, I want to not place this application.
Lordship, I represent CBI. My assisting counsel is before my lords.
Why are you on the virtual board, Mr. Mujumdar?
Lordship, I had to access also Sikkim High Court. There were 2 appeals pending.
Oh, I see. Yes. Not pressed.
7 and 8.
7 and 8 not pressed. Oh, lovely. Brilliant. Not pressed.
Grateful to my lord.
You're opposing.
Yes, officers are present.
My lord, that's CBI officer present in court, that may be noted. That's all.
Record kore now. Not praised. However, we put on record that the concerned officer of CBI is present in court, personally present in court with the case diary. এটা রেকর্ড করে নাও দুটোতেই 7 and 8
Obliged, my lord.
But I am for the petitioner. Lord, I have a request, my lord. I am connected with item number 4. Lord, if you lordship can take up this matter also, item 4 and together, my lord, same
Four
case
has-
diary.
Mr. Bojumdar, 4 has been adjourned till the next circuit. Let's take up 9. Let's see now.
Yes. My lord, this is a case under section, my lord, 302. My lord, the petitioner is in custody for 146 days. My lord, charge sheet has been filed. Trial has not been progressed as of now. Your lordship will find that de facto complainant, but his brother was returning from market, from
Which
station.
service?
But the allegation is 3 persons they have assaulted. They are Anand Roy, Utshab Roy, Tukai Roy, and one Naveen Roy. But these are
Mr.
the 4 persons.
Bojumdar, you did not press your application on 24th of September.
Is it? My lord,
24th of September, you did not press your application.
But the custody was, that point of time, charge sheet was not filed and custody was very less. That.
Yes.
Ground the charge sheet has been
Now, my lord, charge
They
sheet has
withdraw
been
the
filed.
application. Or, my lord, kindly
Because
see the order, last order.
we need to incorporate the provisions of the provisions
Yes.
of the charge sheet.
On the ground that charge sheet was filed, you did not press. Look at
Yes,
the
my lord.
order.
Lordship,
What
at that relevant point of time, charge sheet was not filed. So we came up with that application, and the certain provisions of charge sheet need to be incorporated. That's why we took the leave and wanted to file it along with the provisions of charge sheets and all that.
Sir, what
Yes,
is
where
the
is that order that you took the leave?
The order says, listen to us. Advocate appearing for the petitioner seeks to withdraw the 2 petitions on the ground that charge sheet was submitted by the police.
Lordship, because when we filed the application, charge sheet was not filed. We need to bring the provisions of all to the charge sheet.
During the pendency of the
Anyway,
application, my lord,
what
your
is-
lordship,
what
my
is
lord,
his involvement?
Lordship,
is-
direct involvement,
Show us.
160, yes, lordships.
Show us. Any eyewitness?
Yes, 6 eyewitnesses.
Yes, 164.
Statement.
Give us.
Give us.
Even one had been to rescue that persons, he also beaten up. And
Show
yes,
us.
lordship. Lordship.
my lord, kindly see
Yeah,
any
can you
active role has been played by the present petitioner or not. This is number 1.
Let us see.
Lordships.
Just to set an example, my lord, as no one is above them. And first,
You are not ready with the case, Dowry.
I am very much ready, my lord. There is 6 164 statement here, lordships. And all stating their name. 164 eyewitness.
They are the habitual offender, similar type of offense has been registered against them.
It's a fit case for custody trial.
Yes, this is a statement of before by the accused persons
Before
to the witness. No, this is a statement to the accused person. This witness stated before the magistrate on the basis of the whatever facts was told by the accused persons. No, the first page.
Can we see 164 statement?
No, Reboti Rai, okay.
Lordship, there is 6, there are 6 164 statement. Can we see page 110? Revoti, thereafter 1010.
Yes, that we are seeing. 109.
And thereafter continuous 164.
Yes.
And all are stating there. And the one of the victim.
Sir, the statement you showed us, she is not an eyewitness.
No, thereafter, your lordships.
Yes.
So when we ask for
111, yes.
Yes, my lord.
Not here, not to.
All are stated.
What is the name of the victim?
Victim is now already gone, Bole.
Kalipad Roy, Kalipad Roy.
Everyone see, even some procedural statement that stated that they are killed.
Mr. Mujumdar. We have seen the material in the case diary.
My lord,
We have seen the material. We are not
Yes,
inclined at this stage. Do you want
As
to
your
press
lordship.
it? Then they will suffer a rejection.
but then not pressed, my lord. Let it be not pressed.
My lord, what's in the applied mind of the.
Next. My lord, item number 10, I am for the petition. My lord, this is a case of 304B. My lord, there are 3 petitioners. 1 is husband, 2 and 3 father-in-law, mother-in-law. My lord, I have a humble request before your lordship. My lord, kindly consider so far as 2 and 3 is concerned. My lord, so far as my lord, petition number 1 is concerned, my lord, he is the husband. Within 8 months, the victim died. My lord, so far, my lord, I am not pressing hard for petition number 1. But my lord, kindly consider petition number 2 and 3.
Yes,
They're old
after how many
parents-in-law.
days of the marriage the victim died?
Lordship, within,
For 8 months,
the
8 months, 8 months.
within 8 months, and at that time, she was conceiving and 10 weeks, 10 weeks photos, male photos also expired due to hanging. There was a continuous incessant cruelty, continuous demand
Okay,
of dowry.
let us see the statement. Any 164 statement?
No, 164, 161 statement.
Well,
sir.
yes, 161 by any neighbor.
Brother,
Okay, let us.
mother, 161 statements.
Okay,
are
death
recorded.
by hanging.
Hanging. And
Hanging, my lord.
18 years of aged lady, she was pregnant.
He's saying he's not pressing hard for the husband. In-laws, what is their implication?
All are involved. All are sailing in the same boat.
But my conscience doesn't permit. But my conscience doesn't
Yes,
permit so
which
far as
page?
the husband is
Neighbor
concerned.
statement
My lord
is-
can consider the parents-in-law.
Page 16, page 17.
Page
Page 16 is 16, 17.
What is the age of the in-laws?
My lord, they are aged parents. My lord, my junior is there. My lord, he can. My lord, I mean, before the court, he can tell your lord.
Yes, who
60 and 64.
60 and 64.
My lord, all are interested witnesses. Your lordship will find all the family members of the victim.
No neighbor statement.
Neighbor statement.
Brother,
Page, nah, neighbor statement, neighbors.
because sir,
39, 40.
they're all interested witnesses. Brother, mother.
Lordship will appreciate one fact that the section 304B is there. That means that there is a statutory presumption of guilt. Here the accused has to rebut.
Okay,
Here the accused has to rebut. Page 39, 40. That's right.
Charge sheet is submitted.
Charge sheet submitted.
Yes, my lord. Charge sheet filed. I am in custody for 280 days. We are in custody.
All 3 are in custody for 280 days.
Yes, my lord. Yes, my lord. That is the reason I told your lordship my conscience doesn't permit to
Okay,
press.
when it
so far
was
as
last
the-
rejected? When
Lordship, this is a
September,
renewal. This is a renewal. It was last rejected on
August, 21st of August.
21st August.
21st.
And no new cases, no new.
No, charge
Events have
sheet
been made
was
out.
filed when? Charge sheet was filed when?
In the case diary.
Charge sheet is-
Charge sheet submitted.
May.
Lord, charge sheet filed
After
8th of
filing of charge
May.
sheet,
8th of
after
May.
filing of charge sheet, their bail applications were turned down by the coordinate bench. Charge sheet was filed on 8th May
But that
2020.
is
Charge framed.
No, Lordship. The issue is that
not yet. Lord, trial has not been
accused
started.
let out. There was an accused let out. After that, an RG petition has been filed. So it is pending for hearing.
So,
One
so
accused has
further
not been
investigation
sent
has
up.
been directed.
One
So
accused-
we are
but one
going
accused-
to the-
So, but these three accused are concerned, charge sheet is submitted.
Charge sheet submitted.
Yes, yes.
Lordship, kindly appreciate only 2 points. One is within 8 months of marriage, she committed suicide, and in the post-mortem report, clearly stated that 10 weeks male fetus.
Issue. We are not allowing the husband's application, but in-laws we are. The petitioner number 1 is the husband,
Yes.
comma. The petitioner number
Yes.
2 is the father-in-law, and the petitioner number 3 is the mother-in-law of the victim lady who killed herself by hanging. Stop. The charge is under sections 498 capital A oblique 304 capital B IPC
Oblique 34.
oblique 34 IPC. Paragraph. The petitioners say that they have been falsely implicated. Stop. They did not mete out any cruelty or torture to the victim lady. Stop. They say that they are in custody for 281 days. Stop. Nothing has progressed in the trial. Stop. They renew their prayer for bail, which was last rejected on
21st August 2024.
August 21, 2024. Paragraph. Strongly opposing the prayer, learned state counsel says that the victim lady died within 8 months of marriage.
And she was 18
Stop.
years old.
At that time, now she was 18 years of age. Stop. At the time of her death, she was carrying a child. Stop. The evidence against the petitioners is overwhelming. Stop. Bail should not be granted, should not be granted. Paragraph. We have considered the material in the case diary and the statements including the statements of witnesses recorded under section 161 CRPC. Stop. We do not find any statement having been recorded under section 164 CRPC. Stop. The brother and mother of the victim lady implicate the petitioners. Stop. However, we have to keep in mind that they are interested witnesses. Stop. The neighbor statement is there.
Neighbor statement is there.
Where? Which?
Page 3940.
3940. Stop. We have also seen statements of neighbors. Stop. The allegations in such statements are general and omnibus. Stop. Paragraph. On an overall consideration of the facts and circumstances of the case and the fact that charge sheet has been filed upon completion of investigation, and that both the petitioner numbers 2 and 3 are senior citizens aged 64 and 60 years respectively, comma, we are inclined to grant bail to the petition numbers 2 and 3. Stop. Another ground for this is that, 2 and 3. Paragraph, however, we are not inclined to grant bail to the petition number 1, being the husband of the victim lady, comma, at this stage. Stop. The application is dismissed insofar as the petition number 1 is concerned. According
Lordship,
to
one indulgence.
2 and 3.
Both the petitioners shall not enter within the jurisdiction of Sitai police station.
Yes, with you. With you.
My lord, they are the permanent resident and the house of the complainant is different. How can they say this, my lord?
Have to do it, Mr. Mojumdar. If you want the privilege, you have
Yes.
to adhere
As
to
you lord.
certain conditions.
Much of.
As you know, deeply obliged. My lord, 11, I am also petitioner here in item number 11. My lord, this is a case, my lord, the victim and the petitioners, they went for a picnic. My lord, after my lord, finishing the picnic, when they were returning their respective houses, in the midway, the dispute cropped up. So, my lord, allegation is this, my lord, one Dipankar Rai has assaulted the victim on his head with a stick, and I am the person who supplied the stick. This is the allegation. But it is also pertinent to mention that last my prayer for bail was turned down. Your lordship will find that order in page 9. But my role is restricted. I supplied the stick. That is only, my lord.
Yes, but that is recorded in the 22nd August order. That
Yes,
is,
my lord. That is,
having
But
noted that,
After that complaint has been examined. Yeah, after that complaint has been examined.
so what? On merit, your bail prayer was rejected
Lordship,
by a
after
court.
that complaint has been examined before the court.
my lord,
Before the
complainant,
it will
the
contradict.
main
It is a
complainant-
complainant.
Lordship.
Let us see.
Lordship.
Oh, I
Yes,
see.
yes. Well, kindly see that. See the evidence.
It's in,
Have you annexed?
yes, Lordship.
Where?
Yes, my lord, we have annexed.
Page number 37.
My lord, page 37.
My name does not
Annexure
transfer.
P9.
Page 37.
Page 37.
Page 37, Lordship. I am Shunandan, Lordship.
And where is the written complaint?
Written complaint is, Lordship, is in page number
My lord, 11.
12.
1.
11 and
12
12.
is
Page 1. Written complaint, my lord. Name has been transferred. And thereafter 160.
Moreover, he was taken-
Eyewitness, name has been transferred.
164 statement.
Yes, yes. So,
My lord, I shall request your lordship to please see the, my lord, the nature of 164 statement.
Okay, see, earlier one accused person's bail was allowed.
Yes,
This
Lord.
person-
2 persons. 2 persons.
Separate footing.
2 persons. My lord, they were also present but did not pay any active role.
Weapon with a scooty, and thereafter assaulted, my lord. As per the 161 statement, 164 statement, at the written complaint, my lord. This is a
No,
highly
so far
corroborated
complaint is concerned, it is filed after taking information from the eyewitnesses. His complaint was,
No, he was present. He was the present, and the principal.
Who has been granted bail? What is his name?
My father has been granted bail, Shunandan's father.
What is his name?
Bishwaguru.
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 But Bishwa was also there.
Yes, Bishwa was also there, Lordship.
Also, the matter, he's got the, not assaulted, my lord.
Okay, where is the statement against this person?
164 statement, my lord, kindly.
Page?
Please, my lord, page 60, my lord.
Charge sheet
One
file.
six.
60.
Charge sheet file, Lord.
Page 60,
Charge
my
sheet
lord.
file.
Complaint has been accepted.
Page 16.
60, my lord, 60.
60.
60.
Page.
Page 60.
My lord will find there, only I have
And
supplemented
also, my lord, PM report also. Page 60. This is a Somiran Chetri is the one of the eyewitness, my lord. Independent eyewitness. He reached for the spot with the scooty and she carrying the offending weapon. Present petitioner and Dipankar Rai.
My lord, kindly see who has assaulted.
Present petitioner carrying the offending weapon and both.
Present, Dipankar is the assailant. Vishnu Guru.
Yes, Dipankar Rai is in custody.
Dipankar Rai is in custody.
He is the assailant.
Custody.
He is the main person.
He is the assailant.
Yes.
My lord, the present petitioner got the offending weapon, my lord.
Yes, maybe, but he is not the assailant. Yes.
This the spurs.
How long are you in custody?
And that
More
is
than 10
also
months, Lordship. More
considered
than
by
10
the
months.
People's Bench also, my lord.
What is the stage of the trial?
My lord, Stalin is in Wellspring.
Lordship,
Today is fixed
the
for
issue is that
3 and 4, my lord.
How many witnesses?
My lord, 16.
16 witnesses,
My lord,
repeated calls were given to the other witnesses, only complaint has been examined till date.
So one is in custody, one is in bail.
who is in bail, my lord,
No, no.
Okay. And custody, how many accused are in custody?
My lord, two are in custody.
Two accused person, two principal accused person into the custody, my lord. So, but if present petitioner the person who got bail, my lord, they have no active participation.
তুমি তো বলছো আর
Yes, please take down. Learned advocate for the petitioner and learned advocate for the opposite party, state of West Bengal are present. Are learned advocates for the parties. Learned advocate for the petitioner submits that his client is not involved in this case and one co-accused person is already on bail. Learned advocate for the opposite party submits that the accused person who was granted bail stands in a different footing and this present accused person is also involved along with the principal accused person. Learned advocate draws attention to 164 statement in the case diary and further submits that his prayer for bail was last rejected when 22/8/2024. Upon perusal of the materials in the case diary and upon hearing the learned advocates, this court is of the view that as the trial is in progress, it would not be proper to make any observation with regard to the merits of the case. However, considering the total number of witnesses to be examined is 16. 16, and that one witness is examined, and the fact that there may not be an early conclusion of trial. This court is of the view that considering the nature of the allegation against this petitioner and his period of detention, in the interest of justice, the petitioner should be released on bail. Thus, we allow the prayer for bail made by the petitioner. Hence, it is ordered. Okay, so to meet the OC of the concerned police station twice a week, shall not meet the persons acquainted with the facts of the case, and shall not leave the jurisdiction of the trial court, and shall not
And
do any
if-
act prejudicial to trial.
And each and every day he will be present before the trial court.
Yes, that's a paragraph. It appears that one Vishnu Guru, a co-accused person, has been indulged on bail. From the statement of an eyewitness recorded under section 164 CRPC, we find that both Vishwaguru and this petitioner, who is Vishwaguru's son, correct? Were present at the place of occurrence. However, one people called Rai is the assailant who dealt the blow on the victim with his head.
Yes.
Deeply obliged, my lord. Kitna hai next?
Not after the
Yes.
126, 111, 180, 174, 182. Basically, my allegation of ADS hurt and the attempt to murder earlier.
26 and 307.
Yes, how long you're in custody?
I am in custody.
90 days.
Nature of injury?
Nature of injury, my lord, previous, my lord. Page 57.
Not there.
Yes, my lord, it is there. Previous, my lord. I'm showing the injury report.
Yes, the
mother and the two daughters are the victim. The mother and the two daughters are the victim. Three are the victims. My lord, what happened, my lord? The two daughters, my lord, were loitering, my lord, in front of their house. All of a sudden, my lord, this accused petitioner, my lord, inflicted the injury. With my lord.
Why?
My lord, there was a, my lord, their claim was, my lord, that there was a land dispute. The accused person would not allow, my lord, the victims, my lord, to use the, my lord, land.
don't cutting it off, by proof of people. Yes, what is the statement of this?
Injury reports are there, my lord. Kindly see that.
Injury reports are there, yes.
Injury report, one second, my lord, 3% have been injured. And regarding the 164 statements, my lord, it is at page number 73, 74, and 75, my lord. 164 is at page number 73, my lord. 73.
Yes, statement of this person.
Yes, my lord. 73, 73, 74, 75.
Victim.
Yes, my lord. All the victims have recorded 164, my lord.
All of a sudden, they have been, my lord.
Consistent statements, all the victim statements.
Yes, 164 statements.
Were they admitted in hospital?
Yes, my lord.
How long they were in hospital?
Yes, my lord.
How long?
My lord, I have to see the, my lord, the admitted part. My lord. I have only folded the 164 statements, my lord. 164 as well as the medical.
There was an injury on the shoulder.
Injury is described as simple. Described as simple. We are not saying so.
Might have been, but my lord, there was a deep cut injury on the shoulder. All on a sudden, my lord, they inflicted the injury, my lord, with a weapon, my lord. It may have been knife or my lord, sword.
My page 29 and 30, my lord, can you see page 29 and 30, my lord? Can you see page number 29 and 30?
Yes, any weapons recovered?
29 and 30, my lord.
Yes,
Page
any
29.
offending weapons recovered?
Offending weapons, my lord, Caesar is at page number 23.
Okay,
Caesar
29
at
and
page
30.
23 and that are the photographs, my lord. How, my lord, back cut, my lord, regarding the injury.
29.
23, Caesar list.
23.
Plaintiff's team keeps my lord subjected to threat, my lord. Because they are the my lord, next door neighbor.
Who is Pratima Dev?
Pratima is my lord, the mother, my lord.
Who's
Mother of the,
Mother of the?
mother of the my lord complainant.
Caesar was
Complaint was
from
made.
Caesar was from Pratima Dev's house.
Yes, my lord, they have left the wooden bottom and all.
Okay, so they went
In
and
front of the house, my lord,
In front of the house.
and flew away.
You away, my lord.
At the intervention of the my lord, other neighbors. If they release from bail, my lord, I will be subjected to threat, my lord. Because they are the next door neighbor. Consistently, my lord, I have been
They are
subjected.
your relation. Jethu Jethima saying.
I thought there's some local young
Only, my
person.
lord, dispute cropped up with regard to a piece of land. They won't allow us to, my lord, the use the piece of land. That is the only reason.
Anyway,
While I was loitering in front of the house, my lord, they inflicted that attack. All on a sudden.
Anyway, we restrain them from entering that land.
In this area also, this locality, this locality, will restrict them. They won't enter this, this person will not enter the locality.
The helpless woman, my lord, will be subjected to threat, my lord. Because they are the, my lord,
The petitioner says that he has been falsely implicated. So, there is a land dispute between the petitioner's family and the family of the de facto complainant. So that is why this false complaint has been lodged. So he is not involved with the alleged offense in any manner whatsoever. So he is in custody for 90 days. So investigation is complete. So charge sheet has been filed. So his continued custodial detention is unnecessary. Paragraph. Opposing the prayer for bail, learned advocates for the state and the de facto complainant draw our attention to the material in the case diary. So we have seen the injury report. So the injury is described as simple. So we have also seen statements of the victims recorded under section 164 CRPC. So paragraph. On an overall consideration of the material on record and the possible extent of complicity of the petitioner in the alleged crime, and also considering that charge sheet has been submitted, submitted upon completion of investigation, we are of the view that further custodial detention of the petitioner is not necessary. So hence we are inclined to grant bail to him, but on stringent conditions. We will not enter the police station. Where does the হ্যাঁ পেয়েছো কি বলবো আর বাকি যেগুলো থাকবে সব করে লোকালিটি নয় ভূষণাতে ঢুকবে ওই পুলিশ স্টেশন ঢুকবে
Volunteer performing duty at night, employ vehicle in suspicious condition. So on motor vehicle on four-wheeler vehicle in suspicious condition in Bajan area, thereafter they try to catch the vehicle, they try to trade it. And one person, staying there, one person not fire.
from the vehicle.
From the vehicle, this is the allegation, madam. They are saying that, oh, all this person came here for committing that. This is the allegation, madam. They level the charge. And the preparation of that answer, madam. No one, madam, since no one is about any kind of injury, madam. Only MC card is was required from the spot and then at the time of registration of the bed, no, nothing was incriminating was required from them, madam. That sheet from me, madam. Only.
What was recovered from these petitioners?
Now,
How many accused persons? Three. You appear for two of them, your is for the other. Yes.
Lordship, it states in the use of the line of Dacoity. So TI parade was said, but the investigating officer that charge has been filed against the where number of
So Dacoity was not committed.
No, that is your preparation, it is the allegation.
You were preparing to commit dacoity.
Yes.
What was your plan? What will you do?
That is, actually don't do the prosecution, why they are investigating these parts because they are deciding the other state, that's not the. So far, no recovery was made.
Oh, they are from which state?
Lordship. Lordship, the numbers of guilty verdicts which was committed by the constable at the police station, not from the field. If the cartridges, the blank pen is made by the police power, then that certainly the articles were recovered from the place of occurrence. Not after that, the constable is handed over 3 numbers of empty cartridges which was recovered by the IO at the police station. So no recovery was.
So these persons were arrested from the spot.
After a lot of days, the loss. Allegation there is no name in the FIR. One ticket was mentioned in small car standing near.
Very good. Let's hear the.
My lord, in this case, my lord, the allegations are section 310 subsection 4, that is making preparation to commit dacoity. And second is being one of the 5 or more person assembled, that is section 310 subsection.
That is 399 and 402
All of the news.
of the old act.
And 121 is the voluntary causing to deter public servant from their duty. And assault to public servant, but they have fired, my lord, 3 cartridges were recovered. Now they were collected by the constable and they were later taken to the police station from where those were seized. Now there were 2 groups of persons. There were CCTV camera footages, but they were not so clear. That's why TI parade could not be done. Now this set of persons, they have been arrested from Uttar Pradesh. And the person who was carrying the arms is still absconding. Charge sheet has been filed. And we have already issued the process warrant of arrest against those accused persons who have done, because arms has not been recovered.
Arms has not been recovered.
How long are you in custody?
93 days, no one seen the incident, who, charge sheet submitted, there is no mention in who have possession of the arms, in the charge sheet. My lord, I will decide in the same jurisdiction if you have direction, my lord. My lord, in the charge sheet, they are saying that arms not recovered. In the charge sheet, they did not say that which accused person was in the arms, my lord. There is nothing.
মানে অন্য একটা ইয়ে হোক তারপর অন্য কিছু ধরা পড়ে এসো দুটোই একসঙ্গে নাও দুটোই না আলাদা আলাদা করে নেবো the petitioners are 2 out of 3 accused persons. How many accused persons are there?
The charge sheet, there are 12 values.
2 out of 12 accused persons. Stop. Several koro. 12 korona. 2 out of several accused persons. Stop. The charge is of preparation for committing dacoity. Stop. They say that they have been falsely implicated. Stop. Nothing was recovered from them. Stop. They are in custody for 94 days. Stop. Charge sheet has been filed upon completion of investigation. Stop. They pray for bail. Paragraph opposing the prayer, comma. Learned State Council points out that these petitioners were arrested from Uttar Pradesh. Stop. They are residents of Uttar Pradesh. Stop. There is sufficient incriminating material against them. Stop. He draws our attention to the material in the case diary. Stop. Paragraph. We have considered the facts and circumstances of the case. Stop. Prima facie, there appears to be material against these 2 petitioners. Stop. If granted bail, comma, there is every possibility of these petitioners disappearing as they hail from another state. Stop. Paragraph, in view of the aforesaid, comma, we are not inclined to allow the petitioners essay for apostrophe, prayer for bail, comma, at this stage. Next out, same hobe khali
One petition.
single petitioner. Same but single petitioner. এই আরেকটা দিয়ে দাও the person carrying the arms, firearms, is absconding. And warrant of arrest has been issued against him. ওটাই add করে দিও। Yes, madam.
120B of the president.
On a lighter note, the previous matter was regarding Dacoity, and the petitioner's name here is Dakua. See?
And I got out of 19 witnesses, 2 witnesses have been examined by the and there have been 2 scheduled dates because it's for evidence minor, the witness did not turn up. I have the order sheet. Online copy.
What is the 302 eyewitness? No.
No, my lord, no, I, my lord, 302, my lord, actually, as per postmortem, homicidal, suicidal, page 85.
What's title says 302?
Yes, my lord. My lord, charge sheet also filed in that section also. So, 85, page 85. Postmortem report.
85. দেখছি আগের ইয়েটা দেখুন রোহিত ডাকুয়া
co-accused person bail was allowed, but where in
Page 85.
page 85 is the postmortem report. But their petitioner page 9, my lord. The co-accused person bail order.
Yes, that is there. Is postmortem report.
Manual strangulation. Why are you saying suicidal?
Sorry, my note has been, may be wrong, my lord. Homicidal.
Yes.
Homicidal.
Homicidal in nature. Yes, show us now, show us the.
Now, page 9 of the
Against-
petition.
Yes.
Yes, page 9 of the petitioner, co-accused was granted bail
Bail,
on the
while-
ground that the recovery was made from the house of the
From this
principal accused.
petitioner.
So recovery means recovery
Of the
of
gold ornaments.
sum of, no, so indicates recovered
Yes.
6,500.
No, my lord. From that petitioner. 6,500 from that petitioner. And my lord, the
Take number 12. The accused person from the possession of both the accused person and stolen property.
Page 12.
Of my application. The Caesar list. From whom sees Rohit Dakla, Rajiv Mundra. And the stolen property was found in TVS Apache bike. That has also.
Yes, Caesar was from both of them.
yes.
And one of them has been granted bail. Then,
Now, charge sheet submitted in the year 2023, 7th of November 2023, 17th of November. Charge sheet submitted.
Schedule has been paid with the witness did not matter. I have the order.
Well, out of 19 witnesses, 2 has already been examined. Rest persons.
So on being shown by this two accused persons, these articles were recovered.
Yes.
On being shown by the two accused persons.
accused.
So one accused person is granted bail. This is
From
the,
yes, my lord, that's true, my lord. But from this petitioner, Caesar was also made.
no, here also you see all these articles. Where is the page? Which page of, no, which page is the scissor list? It is legible.
The list, my lord. Now, can I get back the case diary, my lord?
এটা এই হচ্ছে। এর আগে যেটা দিয়েছি বেল সেটা তো পুলিশ ফেলেছে। 6,500 টাকা পাওয়া গেছে মেডিসিন সংক্রান্ত রাজীব মজুমদার।
Actually, my lord, trial is going on, my lord. That is why maybe original Caesar list may be executed.
Here scissor list is not there.
There, my lord, but Xerox.
Let us see. If it is legible, well and good. You see the articles, all these articles were seized.
This is from Rajiv Mujumdar.
Ages 21 years.
No, the petitioner is that. Yes.
এইসব সিজার দেখি আমরা রোহিত ডাকবো বলি রয়েছে
Yes, please take down. Learned advocate for the petitioner and learned advocate for the opposite party are present. Are learned advocates for the parties. Peruse the materials in the case diary. Learned advocate for the petitioner submits that his client is in custody for 1 year, 2 months, and one co-accused person who stands in the same footing was granted bail, and thus the prayer for bail made by the petitioner be considered. When your prayer was last rejected? Okay. Upon perusal of the materials in the case diary, it appears that the Caesar list shows that articles were recovered from the house of both the accused persons. Stop. It further appears from the order dated 6/9/2024 that co-accused Rajiv Mujumdar is already enlarged on bail. As the trial is in progress, although it would not be proper to make further observation with regard to the merits of the case, but considering the period of detention, which is 1 year, 2 months, and the fact that only 2 out of 19 witnesses are examined, there is every possibility that the trial may not be concluded at an early date. Thus, in the facts and circumstances, the prayer for bail made by the petitioner is allowed. The petitioner be released on bail with 2 sureties of rupees. Same. The petitioner will meet the OC of the concerned PS once a week, shall not meet the persons acquainted with the facts of the case, shall not go to the place of occurrence.
But we did not enter the police station.
Yes, objection.
Next circuit, on the request made by learned advocate for the petitioner, let this matter stand over till the next circuit. State.
Eighteen. 19. 19. 18. 18.
My lord,
18 state.
my lord, on merit, I have nothing to say. I have suffered rejection. Lastly rejected on 14th May 2024.
How many rejections? 5, 6, 7,
Twice.
9 times?
3 times.
3 times.
3 times. My lord, I am in custody since 19th January 2022. This is a case of 498 302. Husband is on bail. 5 accused persons are on bail. I am the elder brother-in-law.
Husband is on bail.
Husband is on
Yes, what is the specific allegation
And my
of
lord,
this person?
case is in stagnant condition, yet charge has not been framed.
Oh, charge has not been framed.
Not charge has not been framed.
That means you are in custody for?
2 years, 9 months, and 27 days.
How many witnesses?
25. On not on merit, my lord. What was the merit of this case?
Okay,
25 witnesses, charge has not been framed yet.
Hey, no time.
But charge has not been framed yesterday also.
Yes, which page? Page 88. Oh.
My lord, only on the grounds of detention, and there is no possibility of immediate commencement of trial. Number of witnesses 25. Rest persons are on bail, my lord, including the husband. Near about 3 years, I'm in custody, my lord. Twenty-five witnesses, my lord. Yet charge yet to be framed. I am in custody near about 3 years.
You are not on merit, sir. We really feel pained. Very good case, so much incriminating material. For 3 years, no charge framed.
Tampering witness আবার কি কোনো chance নেই?
Issue.
Yes, sir.
The petitioner renews his prayer for bail, which was last rejected on
14th May 2024, my lord.
May 14, 2024. Stop. He says that he is in judicial custody for 2 years, 10 months. Stop. Even charge has not been framed. Stop. There are 26
25 witnesses.
charge sheet named witnesses. Stop. There is no possibility of an early conclusion of the trial. Stop. On the touchstone of Article 21 of the Constitution, comma, he renews his prayer for bail. Paragraph opposing the prayer, comma, learned state advocate says that there is sufficient incriminating evidence against the petitioner, who is the brother-in-law of the victim lady. Stop. The petitioner's wife poured kerosene on the victim, and the petitioner set the victim on fire. Stop. The victim made a dying declaration before she succumbed to the burn injuries. Stop. All efforts will be made for concluding the trial at an early date. Paragraph. On merits, the prosecution may have a very strong case to secure conviction of the petitioner. Stop. However, comma, that would not justify indefinite incarceration of the petitioner without the trial being taken to its logical conclusion. Stop. Even charge has not been framed. Stop. There are 26 charge sheet named witnesses. Stop. Even if trial was to begin tomorrow, comma, an early conclusion of trial seems impossible. Stop. Paragraph. On the touchstone of Article 21 of the Constitution of India, comma, solely on the ground of delay in progress of trial, comma, we are constrained to allow the petitioner's prayer for bail. Yes, fixed, and then what happened? Tell us what happened.
19 I appear for the petition. My lord, there are two petitioners, and my lord, the offense is one of murder.
Why not?
On murder. My lord, I seek to, my lord, point out the specific discrepancies. Now, my lord, the complaint has been filed by the sister of the victim.
Mr. Ghosh, murder is in BNS, it's 126(2).
Yes. Wrong.
1031.
I'm sorry. 1031. Now, my lord, the sister of the victim files him, my lord, written complaint, which is at page, my lord, 10. She says, my lord, that her brother, she was not present at the PO, but she says later that her brother was throttled by these two petitioners on such and such date, after which he was taken to the hospital, and my lord, he was declared dead at the hospital. Now, my lord, there is an eyewitness in this case who says that, my lord, the victim was, my lord, given fists and blows by these two persons. Now, my lord, the police, during the investigation, seizes 2 boulders and 2 bricks, trying to make out a case that he was perhaps, my lord, he was hurted with the, my lord, boulders and bricks. These are the, my lord, specific discrepancies. She says that he was throttled. The eyewitness says that, my lord, he was administered fists and blows, and, my lord, the police seizes boulders and bricks. And so, my lord, there is nothing in this case which can stand at the time of trial, my lord.
That let
Hence
the
my
trial,
prayer for
that the trial court should
And not
consider.
custody is 66 days.
Inadequate to invoke Article 21. Charge sheet?
Not
It has been filed on 31st of
Sorry.
October 24. But it might have goes to the postmortem report. There are several. Totally, my lord,
This page 8 names this particular person.
my lord, these are.
What you took a look at it? Yeah, go ahead.
And
These are seen to the.
then both Baki Das.
The petitioners say that they have been falsely implicated. Stop. They have no role to play in the alleged murder of the victim. Stop. There are serious inconsistencies between the statements recorded in the written complaint and the statement made by the eyewitnesses. One eyewitness, one.
Yes, one.
The eyewitness, recorded by the eyewitness. Stop. The complainant says that the victim was throttled. Stop. The eyewitness says that the victim received fists and blows from the petitioners. Stop. The police collected bricks and boulders from the place of occurrence. Stop. Therefore, there is grave doubt as regards how the victim died. Stop. Paragraph. Stop. The petitioners are in custody for 66 days. Stop. They pray for bail. Paragraph. Opposing the prayer, learned state advocate draws our attention to the material in the case diary. Stop. তুমি ওটা কি পড়লে একটু যেটা দেখতে নাম হচ্ছে what was that? We have seen statements of witnesses recorded. Now 161 is what?
Under Bharatiya Suraksha Samhita. 183.
182 and 183 নাকি না? 180 and 183. So recorded under sections 180 and 183 of BNS. ওটা কি BNS না?
BNS.
Oh, no, sorry, BNS is that. Stop. These two petitioners are specifically named as the assailants. Stop. As regards the inconsistencies, we are of the view that it is for the petitioners to urge such point before the learned trial court. Stop. Paragraph. For an overall assessment of the material on record and the possible extent of complicity of the petitioners in the alleged murder, we are not inclined to allow the petitioner's prayer for bail, at this stage.
My lord, I am appealing for the petitioner, my lord. My lord, 302 of the Indian Penal Code, renewal of the prayer.
Yes.
302 of the Indian Penal Code. This is renewal of the prayer. My lord, the petitioner has suffered custody for, my lord, more than 200 days. My lord, charge sheet has been filed. My lord, in the month of July of 2024, your lordship will get from the last order. My lord, charge has not yet been framed. Although, my lord, there are 22 witnesses, my lord. The petition, there is no eyewitnesses, lordship. My lord, I am seeking, my lord, bail on.
When your application was last rejected?
My lord, last
It was
reject-
last
24th
rejected
September.
reject of my lord, 24th of September 2024.
Not even 2 months.
Thereafter, my lord, the one rejection, the
There was a
petition has
Puja vacation,
already
my lord.
suffered one rejection. That is, lordship kindly comes to last page, the certified copy, where my lord, it has been stated that since the charge has not yet been framed, my lord, the bail petition has been rejected.
Any other accused enlarged on
After the,
bail
my lord, last
after,
rejection,
after
there
your
was a-
rejection?
Persons, my lord, those two accused persons are before your lordship.
No, any, these
No,
are the
no,
two
no,
accused.
there are no other accused persons.
Only these two accused
These two
persons.
accused persons. Since my lord, 200 days suffered, more than
my lord, there was
200
a
days.
Puja vacation in between, my lord, the intervening people.
My
My
lord,
lord, kindly consider, my lord, the gravity and my lord.
Okay, what is
seriousness
the
of the
statement
trial.
against these two accused
My lord,
persons?
My lord, before that, lordship kindly comes to page 13 of my petition, 17 of my petition. This is the charge sheet where my lord,
the
we have-
headless body of the deceased victim was found floating on the river.
Yes, my
Head
lord.
was, my lord,
Yes, on what basis have these
That
petitioners
is
been
my
implicated?
lord,
connected.
Madam,
Yes, your lordship. Sorry, your
on
lordship.
what basis were these petitioners
kindly
implicated?
peruse, my lord.
Last scene theory, what
Last
is?
scene theory, my lord.
Last scene.
Last scene theory, and both the accused persons have been, my lord, apprehended from the district of, my lord, Kishanganj, within the my lord, the state of Bihar. They were apprehending, my lord. They
Okay,
have
let
been
us see the
apprehended.
statements of this.
My lord, kindly peruse page 165. That is, my lord,
What is the stage? Copy supplied.
no, my lord. Next date on 7th of December for production and framing of charge.
Framing of
Next
charge.
month. It's a heinous and, my lord,
160, this 160
Bullet-
was statement
yes,
is the
my lord,
155.
165, page 165. That is the, my lord, son-in-law of the deceased victim. My lord, the murder weapon, that is a show that has been, my lord, recovered as per the leading statement of this petition. Page
Which petitioner?
Petitioner number 1. Who is the, my lord, the principal perpetrator?
Okay, petitioner number 1.
My lord, both were present, my lord, in the crime scene. As per the, my lord, the investigation, the petitioner number 2, my lord, hold the, my lord, the deceased victim, and my lord, petitioner number 2, my lord, the slaughtered the head.
And recovery was made from the
As per the leading statement of petitioner number 1. And, my
And-
lord, both have been, my lord, apprehended from the same place, from the state of Bihar. The call data records also, my lord, matched.
No, but only one thing, lordship, I want to show you before your lordship. My lord, page 17 of the chart, my lord, of my petition, which is the chart sheet. My lord, this is circumstantial evidence, my lord, no eyewitness. My lord, they have been stated in the chart sheet, my lord, second last paragraph. Later, the blood samples collected from the deceased and her son and husband have been sent to the CFSL, Kolkata Forensic Laboratory. However, due to backlog and processing delay, the result is still pending. These results are crucial for conclusively linking the accused with the crime scene. So, my lord, the petitioner, my lord, has not yet been, my lord, connected with the crime scene as per the charge sheet, lordship. He has suffered custody of 200 days, 22 witnesses, lordship.
You are resident of Bihar.
No, my lord.
No. Yeah, my lord, at any condition,
In
my-
the subdivision of Mathapanga.
Yes, your
Within the
lordship.
district of Coach Bihar.
Shall not leave the jurisdiction,
No,
lordship.
sorry.
Anyway, if the trial does not proceed, you
Yes, come
renew
back
your
later.
prayer.
The petitioners renew their prayer, which was last rejected as recently as on September 24, 2024. Stop. They say that they have been falsely implicated. Stop. There is no eyewitness to the alleged incident. Stop. They are in custody for 200 days. Stop. Even charge has not been framed. Stop. They pray for bail. Paragraph. Opposing the prayer, learned State Council draws our attention to the statements of witnesses recorded under Section 164 CRPC. Stop. The petitioners are implicated by name. Stop. Paragraph. There may not be an eyewitness to the incident, but circumstantial evidence may be sufficient in certain circumstances to secure conviction. Stop. If the chain of events can be completed by the prosecution, conviction can be made on the basis thereof. Stop. We are told that December 7, 2024, has been fixed as the date for for consideration of charge. Stop. Paragraph. In view of the prima facie incriminating material against the petitioners who were arrested from Kishanganj area in Bihar, and given the gruesome manner in which the victim was murdered, whose headless body was recovered from a river, we are not inclined to allow the petitioner's prayer for bail, at this stage.
And one line be incorporated, my lord, this observation will not prejudice to the learned.
Certainly, that applies for all bail orders. Because needless to say, none of the observations made here shall have any bearing on the trial.
I'm grateful.
And such observations have been made only for the purpose of disposing of this bail application.
Grateful, Lord.
We'll come back. The list, it's got it.
I am for the state, your lordship.
One zero eight, that is two of the DNS, but for the question number 4988303 Now, last date 104 days and the action. Charge sheet submitted on 30th of October 2024. Education equivalent after 7 years of marriage from the.
Yes, sir.
Yes, sir, within 7 days of marriage.
7 days?
Yes, my lord. If your lordship kindly have a look at page 63 and 64.
56. 56, you have pulled.
63 and 64. This is the inquest report, my lord.
Page 63.
One sixty was statement of de facto complaint, the father of the deceased.
Yes, page 63.
64 is the relevant portion. Demanding of more dowry, my lord.
In-laws are not accused.
Yes, they are all absconded.
Absconding.
One, another 4 164 statement is there. If your lordship kindly have a look.
Do you have 164 of any independent person?
Yes, my lord.
He is an interested person.
Yes, my lord, at page 36, 37, 39 and 43. They are all independent.
This is page, okay. Any other 164 of the neighbor statement?
Independent, 36.
36, 37. Page 36 and 37.
36.
If your lordship kindly.
Yes, marriage was solemnized 1 month ago or 7 days.
7 days, my lord.
No, but-
25th marriage was solemnized and 30th, the incident was over. Lordship, I have already folded the inquest report. Blood injury is there. On the backside of that body of the deceased, blood injury is there as per the inquest report.
Yes, what is the FIR? Please let us see the FIR.
Yes.
And then we will see the inquest report.
Page 2, my lord.
Page 2.
Page 2.
After how many days the FIR was lodged from the date of incident? On the following day.
On the 2nd August,
Incident took place on 31st.
30th, the 30th July,
30th July.
30th July,
On the third day. After 2 days.
after 2 days. For Lord, 161 statement of several neighboring.
Yes.
Statement under section 161 of neighbor is there.
So 164 statement of the neighbor we have
Yes.
looked into.
And another 161 statement also is there. Of
Which
the
page?
neighbors.
Which page?
At page 7, 8, 9, 10, 11, 12.
Nothing in this statement, sir. What is there? They got married, they invited us for lunch, we went, we had lunch. One of them said the hand of the bride was shaking. This is all that is there.
Yes, take down. How long you are in custody? Yes, learned advocate for the petitioner and learned advocate for the opposite party, state of West Bengal, are present. Yes, charge sheet is submitted.
Yes, sir.
Heard learned
For
advocate
30th
for the
October-
parties,
October
peruse the
25th.
materials in the case diary. Learned advocate for the petitioner submits that his client is in custody for 104 days. And as the charge sheet is submitted, the prayer for bail made by the petitioner be considered. Learned advocate appearing for opposite party state of West Bengal submits that the death of the victim took place 7 days pursuant to the date of the marriage and draws our attention to different statements made under section 164 CRPC by the witnesses. We have perused the statement of section, perused the statement under section 164 CRPC made by the witnesses and also the FIR. Upon considering the statements made by the witnesses and upon further consideration of the materials in the case diary, although it will not be proper to make any further observation with regard to the merits of the case, but considering the period of detention about 104 days, and the fact that charge sheet is already submitted, and upon specifically considering the statement under section 164 CRPC made by the father of the victim and some local persons, we are of the view that in the interest of justice, the petitioner should be released on bail. Thus, we allow the prayer for bail made by the petitioner. Hence, it is ordered that the petitioner shall be released on bail, shall meet the concerned OC once in a week, shall not meet the persons acquainted with the facts of the case, and shall not leave the jurisdiction of the court. We make it clear that our observation are only for the bail application, and it will not affect the trial of the case.
Yes. I am grateful to you, Lord.
For the petitioner not being custody 172 days in custody, your lordship granted bail to the other go-ahead person standing on the same footing. Annexure P3, page 14.
But these instant petitioners are not dwelling on the same footing.
Three petitioners are granted bail. So lordship was on due below. All 8% are on his same, standing same position below. And out of that, 3% was granted bail.
Yes. Yes, which page?
My lord, 164 of the, my lord, eyewitness, page 176. 176. My lord, these petitioners are, my lord, the principal architecture of the entire tribe. The petitioner number 1 and 2, my lord, happens to be, my lord, the cousin brother. On that intervening period, my lord, immediately before the incident, my lord, there was a hot altercation between the deceased victim and, my lord, the petitioner. Hindi, my lord.
You understand Hindi?
No, my lord.
I'm for the de facto community. I do understand.
Lord, Mr. Ujjwal, someone translate.
petitioner Karan Goa,
Atif Chhetri.
বর্তমান petition বর্তমান হচ্ছে এই সুন্দর
And my lord, most surprising fact is that, my lord, my lord,
anyway, yes. Okay, then let me fold this page. Okay. See, North Bengal people understand Hindi. That is what I knew.
it is our, my lord, fault.
So I understand, I follow, but I can't read that.
Lord, that is the problem.
Why do you read it? We follow it, we understand.
Oh, now we recollect.
moving the application. Lordship, kindly, after the rejection on 21st August 2024, the charge was framed. Kindly cease, Lordship. The co-accused has been enlarged on bail.
Co-accused from whom there was no recovery.
No recovery, as because he was the person driving the scooty. Subsequently, he managed to escape. Lordship says several dates were fixed on page 2 for evidence.
So it was 21
3 months.
2024.
None of the witness turned up before the court.
Correct.
No, madam. No, my lord. Okay, please.
Yes, what certificate have you annexed regarding your disablement?
Let him, he must be having the.
Irrelevant. এখনো disable could নয়। এখন is only on delay। এখন only on delay because আগের অর্ডারটায় if the trial does not proceed while rejecting his presence this will not prevent the petitioner to renew in the event the trial is not commenced। এটাইও বলছে trial commence করে না। আর আমি 3 দিন almost 1 year.
Commercial quantity lordships and only 9 witness, next date has been fixed on evidence, charge already framed, 21st 11/24, that is 14 your lordships.
They're
And
on
only 9,
on 21st August 1, 2, 3, 4, 5, 6, 7, 8, 9 dates were fixed.
actually, sometimes your lordships, they are taking.
You just tell us that one witness turned up on any particular date.
Fixed on 21st 11.
Is that our question? What is our question?
So for the series concern, charge already has been framed.
What is our query, sir? You are fudging the question. On these 9 dates, did the witnesses turn up?
Commercial.
Either yes or no.
Actually, I don't have any from the corner of the city, there is no reflections. Status report is recorded.
Lordship, here's a certificate copy of the order.
Because whether they took time or not, I don't know. In the city, there is no reflection.
It was the duty of the state to appraise whether I have taken time or not. I'm showing Lordship, the witness did not turn up.
But this, whether you take the time for evidence, from the city, this is not reflected.
Person who brings the allegation, the judge burden of proof lies of him to prove the same.
Certified copy. 23rd September. Learned special PP present without any witness. Number 1. Next day, 25th September, no witness. This goes on.
Same.
Goes on. Issue. Sir, we have repeatedly say we are pained to grant these bails. Thing is that your witnesses don't come. The petitioner renews his prayer for bail, which was rejected on July 29, 2024. Stop. While rejecting his prayer, a coordinate bench had observed Kolundao, the court koro. It is made clear that nothing in this order shall prevent the petitioner to renew similar prayer in the event the trial is not commenced expeditiously. Stop, unquote. Paragraph. The petitioner says that he is in custody for 308 days. Stop. On
21st August. 21st August. Charge.
নিয়ে নাও কেন তোমরা দুমদাম?
21/8/2000
হ্যাঁ না এটা তো আরেকটা এইটা হ্যাঁ he says that on August 21, 2024, i.e. the day when the charge was framed, the learned trial court fixed 9 dates between September 23, 2024 and November 6, 2024 for examining the 9 prosecution witnesses. Stop. He produces certified copies of orders recorded by the learned trial court on those dates, which would show that on none of the dates the prosecution witness turned up. So, as a result, comma, the trial has not yet begun. Paragraph. On the ground of delay, paragraph now it is on the ground of delay, the petitioner renews his prayer for bail. Paragraph opposing the prayer for bail, comma, learned state counsel says that commercial quantity of
syrup, Lord.
Cough syrup along with the tablets, huge quantity.
commercial quantity of cough syrups along with contraband tablets were recovered from the possession of the petitioner. Stop. There is clinching evidence against him. Stop. All efforts will be made to bring the trial to an early conclusion. Stop. Paragraph. We do not see how the prosecution can ensure an early conclusion of the trial. Stop. Going by the conduct of the trial, comma, that seems to be highly unlikely. Stop. 9 dates were fixed by the learned trial court to examine the 9 charge sheet named witnesses. Stop. Not on a single day the concerned witness turned up, coroner, presented himself in court. Stop. Paragraph. Going at the pace, going at this rate, comma, it is anybody's guess as to when the trial will conclude. Paragraph. We cannot lose sight of the fundamental right of an under trial to personal liberty and speedy trial. Stop. Those factors must override all other considerations. Stop. The prosecution may have an excellent case to secure the conviction of the petitioner. Stop. That, however, comma, would not justify incarceration of the petitioner for an indefinite period of time. Stop. Solely on the ground of delay in progress of trial, comma, we are constrained to allow the petitioner's prayer for bail.
Deeply obliged. Deeply obliged.
I'm for the petition.
State is there.
Yes. My lord. Violation of clause 14 of NDBS rules 22. After 4 months of receiving the sample, the report was made.
Sir, we will be deciding this next circuit. Next circuit. We have reserved a judgment. Next circuit.
My lord. 32. I'm for the petition. 32 states.
32 state? Yes. What was recovered?
My lord. The cough syrup, my lord. There is.
Here also
violation
same
of-
point.
My lord.
Same point, violation of Rule 14.
No, not more. 52A, my lord. Samples recovered from the spot were sent to the FSL and inventory was made later on.
Is that correct, Mr. Ganguly? Do you have our order?
My lord, no. I have not.
No, we have passed orders on this point.
Page 70. Page 70 is the central sent for examination. Particularly when not of the day, that is on 27/7/2022. Lordship here. 27/2/2022.
Sent.
Sent. And certificate of inventory on Lordship, page 82. Kindly since the date.
Tell us.
38/7.
Then what he says is correct.
Another point, my lord, another great point, my lord. The thing is that,
Issue. The petitioner says that there has been gross infraction of the provisions of section 52 capital A of the NDPS Act of 1985. Stop. Sample was sent to FSL prior to certification by the concerned magistrate. Stop. This would dilute the restrictions in section 37 of the NDPS Act. Stop. He prays for bail. Paragraph. We have learned State Council produces the case diary. Stop. We find that the samples were sent to FSL on July 27, 2024. 24. 22. Stop. However, certification was done by the concerned magistrate on July 30, 2024. Stop. Therefore, paragraph no coming. Therefore, the petitioner is justifiably aggrieved. Stop. Paragraph, in view of the aforesaid, we are constrained to allow the petitioner's prayer for bail.
I'm very grateful.
দেখে দাও তো হবে না দেখে দাও
Item number 2.
Sir, we are reserving judgment. I have not had the time of going through the papers. We are reserving. Hey, লিখে নাও এটা. Item 1P enter লিখে নাও. Hearing is concluded, judgment is reserved. We'll deliver from Calcutta.
Item number 33.
And I am for the petition. On the basis of statement of
Yes.
on the basis of statement of coactus petition name transfer.
No recovery.
Item number 24, that Bobita, which was not press ultimately, he is the husband of Bobita. The contraband articles were found from the house occupied by both.
Anyway, what have you shown in a Caesar list? Recovery?
Recovery from the house.
Yes.
House belongs to the, we have the statement of the owner, that is the landlord, who has given on rent to both the accused person. So constructive possession is there. And may I the owners.
What was seized?
262 ground cigars from 3 accused person. 250 is the commercial one.
Seized from where? Caesar list, Mr. Ganguly, Caesar list.
Caesar list. You must kindly see the page 10, written complaint. Page 10, last paragraph.
Mr. Poddar, we will see the Caesar list first.
House. This is Caesar. That is rented house of that Bobita Roy. That's because Bobita Roy is present there.
No, Bobita Rao is the recorded tenant. Maybe
Yes,
Bobita.
Yes, and because Bobita Roy was present there along with two other person. So it has been mentioned house of Bobita Roy. It is a rented house. But during investigation, and this is this statement, the landlord. There is no tenancy. Landlord.
Landlord gave rent to whom?
Both of them.
Yes. No, both of them very well. But tenancy is recorded in the name of which person?
There is no tenancy agreement or this type of statement. There is no tenancy agreement. Just show that.
Oral. How many tenants can produce written agreement? Suffer a rejection. Hey, issue. Commercial.
Written complaint, paragraph 3, my lord. Paragraph 3, my lord. Last paragraph, my lord. Secret source information, my lord. Can you see ISI Pratap lecture such and such on APO received an information related to secret source that Bobita Roy is illegally procuring narcotic substance. But secret source information, all the affair, all this thing about Bobita Roy, never saying about the present petition.
No, Bobita Roy was issued notice.
No. Bobita Roy was his wife.
Yes, his wife.
I am not.
Charge sheet filed. Charge sheet not filed. Charge sheet. Investigation is going on. No question. Yes. The petitioner says that there was no recovery of contraband items from him. Stop. He has been implicated on the basis of statements made by co-accused persons. Stop. He prays for bail. Paragraph. Learned State Council points out that a co-accused person's prayer for bail was rejected earlier today in CRM NDPS 443 of 2024. Stop.
Ultimately, realizing the view of the court, they have not.
Oh, Judge. In fact, when the court was about to reject the prayer, the petitioner said that she was not pressing the application. Stop. Paragraph. We find from the case diary that the house, we prima facie find that the house from where recovery of commercial quantity of brown sugar was made was rented out by the landlord to this petitioner and the co-accused, namely Bobita Roy. Stop. Therefore, the petitioner was in constructive possession of the contraband items. Stop. Investigation is in progress. Stop. Charge sheet is yet to be filed. Stop. Paragraph. Under those circumstances and keeping in mind the restrictions in section 37 of the NDPS Act, we are not inclined to enlarge the petitioner on bail, at this stage. Mr. Chaudhary, the 1 p.m. matter you were there, no? Yes, we have reserved judgment. I didn't find time to go through the papers. Yes. You gave us a copy. No, the records will be sent back here.
Take back and take a photocopy.
তাই করো বুঝতে পেরেছো? উনি একটা রিট পিটিশন দিয়েছিলেন, ওটা দিয়ে দাও। And please ensure that we get a copy today itself.
Yes, because
Tomorrow morning we have meeting.
it will take an hour probably, then it will be handed over to the court. Grateful, madam. Sorry for this trouble for this consecutive days.
No.
Madam, preparing for the petition.
Yes.
My lord, one I appear.
Is other side?
Sir, Iraq Burman was there.
देखिए फाइल था चलो 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 regarding
They have said that don't forward the recommendation of the compensation department. Only this was the check.
no Mr. Pari, not in the absence of other side. I don't know anything about the matter. Today we are all pressed for time because I have to release my court officers. They are going back today. And unless all the orders are finalized, which we dictated throughout the morning, they will be useless. So let it be next circuit if you like. You're returning today. 6:45 flight. Then next circuit. If you can get him, see, I'll pass it over. Chalo. Next circuit. Here for the petitioner.
For the private.
On the prayer made on type on the prayer made on behalf of the petitioner, let this matter let this matter stand adjourned and be listed before the next available circuit bench.
In item number 3, Your Lordship, I am appearing on behalf of the CGST department.
Yes, but petitioner is not here.
Well, I am appearing
Gurdeep
online.
Chakraborty, I think
May
he's
I
not-
have your lordship's kind leave to appear online?
Why?
Because I appeared, Malad directed the matter to be listed on 12th. I was there physically on 12th. Somehow your lordship could not see it singly and the matter would not be listed on 12th.
Difficult because you are not clear. This audio is not clear at all.
No issue, my lord. No issue, my lord. Kindly keep it next circuit then.
Very well.
Small issue is there. Only small issue is there.
On the request made on behalf of the petitioners, let this matter be placed again before the next available circuit bench.
My lord, one liner may kindly be written because as per direction, as per order dated 6th
File
September
to the
2024, 6th September 2024, there was a direction to serve the notice upon the respondent number 3. And on the last date, they have paid for time.
Well, it has been duly served. I have been informed by the learned advocate on record at Jalpaiguri that it has been duly served. But kindly keep it in the next circuit. We will produce the proof of service also.
Very well. Agar likho a line. Learned advocate for the petitioners says that as per the earlier direction of this court, notice has been served on the respondent number 3.
My lord.
তারপরে লেখো on the prayer যেটা বলেছিলাম.
Well, deeply obliged.
Nobody appears for the petitioner when the matter is called on. Likhcho. Stop. This is the matter. Today is the last day of this circuit. Today is the last day of this circuit. Stop. List the matter once again before the next available circuit bench.
No, I don't know if I am praying for a next circuit. In this matter, Mr. Shumit Sumar is appearing on behalf of the state respondent, but due to personal difficulty, he could not appear.
On the prayer made on behalf of the state respondents, let this matter stand adjourned and be placed before the next available circuit bench. Your appearance will be recorded.
I appear for the private respondents. Sir, I beg to appear for the petitioner in this matter.
Lord, this matter.
Official respondents?
Lord, the state respondent.
State and the affected respondent would be if the prayers are allowed, my lord. I would like to file an affidavit in opposition.
My lord, this is there, he is not at all affected by this order. My lord, let me demonstrate how. My lord.
Why have you made him a party then?
Yes, my lord, we have made him a party. My lord.
Why have you made him a party?
My lord, pro forma
No,
respondent.
that
my
has
lord.
been cleverly done, if I may use this word, my lord. They are praying for a direction upon the police to enforce a order passed by the district magistrate under section 14 of the Surface Act, my property, my lord.
Yes, because they have approached proper forums, they have lost in the
Try to
forums,
know.
my lord. My lord, let me apprise your lordship regarding the genesis of this matter. My lord.
You first satisfy me with about
Yes.
surveys.
Yes, my lord, service, affidavit of service is there.
You are 5 to 8.
5 to 8, my lord.
The secure property is your property.
Right.
So if I pass an order in terms of prayer A, let us say, it will not affect him.
Definitely, it will affect him, my lord. But the thing is, he
But
has
the thing is
exercised
that-
his right, my lord, in the proper forums. First of all, in the
Maybe,
in the
sir,
DM's office, thereafter
maybe-
in DRT, thereafter in DRAT. In,
Lekho.
my lord, may I apprise your lordship for 1 minute, my lord? If
You
your
say
lord,
whatever you want to say, I am going to end up giving direction for affidavits.
Great.
There is
Lord,
no scope for
the
interim
thing
orders,
is,
sir.
15 crores of public money, they are holding that for long period of time. And since, and this, in this petition, my
I
lord,
will give a very short direction,
my lord,
don't worry.
I'm so grateful. I'm so
Short
grateful.
direction. The petitioner prays for police assistance to take physical possession of what it says. Oh, you're the bank.
Yes,
What it says is property in respect of which security has been created in its favor. Stop. Paragraph. The respondent numbers 5 to 8 say that the property belongs to them. Stop. Any order passed on this writ petition will adversely affect them. Stop. They seek time to file affidavit in opposition. Paragraph. The bank says that the petitioner has exhausted, not the petitioner, the respondent numbers 5 to 8 have exhausted all their remedies before the DRT, DRAT,
and thereafter in civil revision by under this.
and also civil revision before this court.
May I just interrupt your lordship, my lord? I have instructions that one proceeding is still pending before the DRT Shiliguri.
Their submission.
I'm sorry.
This is what they are
Connected with my.
Yeah. Stop. Therefore, comma, no useful purpose will be served by permitting the said respondents to file affidavit in opposition. Paragraph. Learned advocate for the respondent numbers 5 to 8 says that one proceeding is still pending before the
District Recovery Tribunal, Shiliguri.
DRT Shiliguri. Paragraph. Be that as it may, comma, since any order passed on this writ petition is likely to adversely affect the respondent numbers 5 to 8, comma, I am inclined to grant opportunity to the respondents to file affidavit in opposition. Paragraph. Let affidavit in opposition be filed within a week from date. Tarikta bracket mention kore debe eksathe. Stop. Reply thereto, comma, if any, be filed within 5 days thereafter.
My lord.
Stop. দাঁড়াও, list the matter. আজকে কত তারিখ? 14.
14th, Milord, 14th
List
of
the matter a fortnight hence before the next
Milord.
available circuit bench.
Milord, only one indulgence, Milord. Let the state be also directed to file an affidavit because the main grievance is against the state, Milord. The SP has been directed for, was requested for 6 times.
Let
Milord,
the
they never
respondents
turned
বলে
up.
যেখানে প্যারাগ্রাফটা বলেছি, কি বলেছি? No, what report? You file it by way of affidavit. Let না ওটা করে ওখানে একটু চেঞ্জ করে দাও all the respondents are permitted to file, all the respondents are permitted, look, I can't force them to file.
Definitely.
Permitted to file affidavit in opposition within a week from date, তারপরে যেটা বলা আছে। হ্যাঁ?
I'm so grateful. Apologize for troubling your lordship on the last day
No,
of the circuit.
what trouble? That's my job.
Will you sing your lordship again here?
Why do you say
Milord,
so?
we'll miss your lordships and bench so much.
Let us see what the divine wishes.
Nowadays, my lord, we don't get much chance to address your lordship there because most of the time we are here.
Yeah, that's right. All the best.
Very great.
দেখো এক নম্বরটা একবার।
Mr. Borman came and left.
Come back before the next circuit. Learned advocate.
No, only prayer, my lord. This is the third time adjournment. Even second, if the next circuit, if nobody is available, then my your lordships kindly make it clear. The order will be passed in absence. So otherwise, they will not appear. What can be done?
Learned advocate for the respondents is not present. Stop. Learned advocate for the petitioner makes a legitimate grievance that this is the third occasion when the respondents are not represented and the matter is being adjourned on each occasion. Stop. Paragraph. Let a notice be served on learned advocate for the respondents, intimating that this matter will be listed again before the next available circuit bench, comma, when, comma, if the respondents are not represented, comma, the matter may be proceeded with ex parte. Whatever it is, for whatever it is worth.
No, otherwise.
All right,
Don't lose the judge, lose the case.
All the best.
No.
Thank you.
Get.